Thank you so much for joining us today for this important webinar and this important webinar series. This is the first of a webinar series that is being organized by the Center for Justice Innovation. There are five webinars in the series, and we are the introduction, and we're going to give you hopefully a sense of just how important and influential municipal courts are and why we should all be examining and paying attention to this important feature of our local governance structure. So my name is Professor Alexandra Nadapoff. I teach at Harvard Law School. I have written about municipal courts, the American lower court system generally, and in particular, the importance of the millions and millions of misdemeanor criminal cases that those courts generate and process. Unfortunately, I'm going to have to restrain myself to very brief introductions of our luminous panel. I could talk for a long time, but we're just so fortunate to have with us today Judge Andre Sparks, who is the presiding judge of the Municipal Court of Birmingham, Alabama, and he is also the co-founder of the National Association of Municipal Courts. We also have Blake Strode, who is the executive director of Arch City Defenders in St. Louis, Missouri, which is a legal advocacy organization that combats the criminalization of poverty and state violence. And Arch City has been a very active and influential player in the conversation around Ferguson and municipal courts and the role of municipal courts in Missouri. And we have Professor Laura Edwards, who is a legal historian. She is currently the acting chair of the Department of History at Princeton University, and she is the author of the book, The People and Their Peace, which is a history of local courts in the period after the American Revolution. I'd like to kick us off by just flagging some of the big issues that I think we get to engage when we engage the phenomenon of municipal courts. And I'm especially excited about this webinar series and this project because I think that the importance of municipal courts are underappreciated, at least currently. It's been some time since our public discourse has really appreciated the role of these courts. And I want to take the opportunity to share, if it will let me, share with you. Let's see, did it work? Yes, I see people nodding. Just to give you a sense of the size and the scope of the phenomenon, which people don't always realize. So this is the Criminal Municipal Courts Project. It's a website that I run here from Harvard. And we're building out this resource. We hope that it will become a helpful resource for the public, for legislators, for judges, for advocates, and for educators about municipal courts and data, resources, and scholarship about them. If you're interested in being kept up to date, please go ahead and join the mailing list. Just give us your email and we'll keep you up to date. But this data visualization just gives you a sense of just how pervasive and important the phenomenon of municipal courts are. Most states have municipal courts. 30 states out of the 50 have them. In total, there are over 7,500 municipal courts in the United States. That's more than all other sorts of criminal courts combined. Together, these courts process over 3.5 million criminal cases. That's not including routine traffic cases, and collect over $2 billion, that's billion dollars in fines and fees. All of this is to say that this is not a niche phenomenon. This is not small. This is a central part and a large part of our judiciary and, of course, our criminal system. So I'm going to unshare now. And so this data also helps us appreciate another feature of why municipal courts are so important, because they are a species of local governance. They are created and run by cities. Sometimes they are not unified with the central state court apparatus. About half of all states have a unified judicial system and half don't. Every state does it a little bit differently. And while there are, of course, state lower courts that also process the same kinds of cases, that also process misdemeanors, these municipal courts, the local city-run quality of these courts gives them a special democratic as well as criminal significance. So there's a handful of issues that I just like to flag before we hear from our extraordinary panel. One is, and this is the reason I teach criminal law and criminal procedure, and this is the reason that I initially got interested in the subject, is that municipal courts generate such a large percentage of the criminalization in this country. About 25% of the misdemeanor docket is generated in the United States by municipal courts, which in turn the municipal misdemeanor cases are in turn about 80% of all criminal cases in this country. So this is an enormous part of our criminal system. And municipal court and municipal criminal ordinances are redundant to state criminal codes. So you could violate a loitering state law, or you could also violate a local loitering ordinance. And so it's a way in which this system is really adding on to the already enormous system of criminal law and criminalization that we already have. Maybe the best known challenge, sort of the most infamous challenge of municipal courts that has come to the fore, is the problem of revenue, the impact of the use of fines and fees and the criminalization of poverty that stem from reliance on criminal fines and fees. Of course, Ferguson and the Department of Justice report about Ferguson made this famous, and we're very fortunate to have Blake Strode here with us today, who can share the lessons that we can draw from Ferguson and from the municipal court experience in Missouri. Like much of the American criminal process, the people who pass through municipal courts are disproportionately poor, disproportionately people of color. And indeed, the third webinar of this series is devoted specifically to this problem, and it's entitled Municipal Courts as Potential Sites of Racial and Socioeconomic Disparity. And I encourage you to join us for that one as well. And at the same time, it also reveals the governance challenge, the democratic challenge of this process, because that revenue stream is important to courts. It's important to cities. And so the significance of the fines and fees of municipal court criminal fines and fees is not just criminal. It's not just judicial. It's also economic. It's also political. It's a form of taxation that can be especially tempting for jurisdictions that lack a strong tax base and are thus heavily reliant on other sources. And this, again, is part of the special character of these courts as entities of local accountability and local governance. And this is the subject of the second webinar in the series, which is entitled The Role of Municipal Courts in Local Governance and Democracy. So in particular, municipal court judges are locally elected or appointed by local city councils. And this makes them at least potentially more accessible to and accountable to local communities than, for example, state court judges would be. And moreover, these courts are old local governance mechanisms. They have been around for a long time. And so, again, we're very lucky to have Professor Edwards here, who can help us understand the long, contested, and often promising historical legacy of localized justice like these courts. Last but not least, for the attorneys in the audience, there are some special legal rules that govern municipal courts that are sometimes surprising to people who have not engaged the phenomenon. The U.S. Supreme Court has excused municipal courts, as well as some other low-level courts, from basic procedural requirements. For example, defense counsel are not required when people are charged with fine-only offenses. Jury trials are not required. Judges do not always need to be lawyers. Proceedings do not always need to be on the record. In other words, there can be a great deal of informality in municipal courts especially smaller municipal courts, that would be countercultural in other criminal and judicial spaces. And so for all these reasons, municipal courts are also an opportunity. They are often the first line of our judiciary to face and grapple with the large challenges of American criminal justice: poverty, disadvantage, mental health, homelessness. And these courts can also be innovators. And this is the subject of the 5th webinar, which is called Change and Reform. Judges in different jurisdictions have taken it upon themselves to step up to the challenges of the American criminal system and provide alternatives to criminalization, and services, and support. And we're, again, very fortunate to have Judge Sparks here, who has been a leader in this regard and this space, and he can help us better understand these positive possibilities for municipal courts. So with that, what I'd like to do is turn this over to Judge Sparks. Judge Sparks, can you hear us?
I can hear you fine. Can you hear me?
Yes, thank you so much for joining us today.
I'm glad to be here, and I want to thank the Center for Justice Innovation. And I also want to thank you, Professor Nadapoff, for your advocacy in this area. And thank you for bringing to light some of the issues that are relevant when it comes to dealing with municipal courts. I appreciate the other panelists and look forward to hearing what they have to say in this space. I've been honored to be the presiding judge for the city of Birmingham, Alabama, for the last 14 years. I've been on the bench now for about 29 years in various capacities. And so, but I've been happy to be in this space because I believe it affords me the greatest opportunity to help people in our community. There's a lot of mystery, it seems, around the topic of municipal courts. And that's something we want to try to tear down the walls of misunderstanding. With in Alabama, we have 67 counties, but we have 280 municipal courts in Alabama. More municipal courts, of course, than we have circuit and district courts. But the municipal courts in the state of Alabama have what's called concurrent jurisdiction with the district courts, which means that in those areas where there are no municipal courts, those violations of municipal ordinances are held or heard in the district court, and appeals are taken from the municipal courts to the district courts. The laws that apply in district courts also apply in municipal courts. The significant difference is there are no jury trials, as Professor Nadapoff indicated. All the trials in the cases are judge alone, but every other requirement is there. We have a prosecutor who is prosecutor, a prosecution staff that's typically out of the city attorney's office, and we also have a defense counsel appointed by law. Each court has to have an indigent defense counsel staff, and even though the law in Alabama for indigency appointment of indigent counsel specifically excludes municipal courts from creating their own indigent defense counsel, City of Birmingham mirrors that law when it comes to creating its own indigent defense team. And so the City of Birmingham is invested fully in making sure we have a full staff of indigent defense counsel to represent the parties who come before us. Every type of social ill you can imagine is first seen here at Birmingham and our municipal courts. Every one of them. We deal with a number of minor issues. Of course, we do a lot of traffic tickets, and people think that we're simply traffic court. But we also hear hundreds of domestic violence cases, hundreds of DUI cases, hundreds of assault cases each and every year. And more importantly, lately, and also importantly, lately, we hear a number of drug cases here at this level. Now, they're not big amounts of drugs, but we have people who have drug addictions who come through. And so, as Professor Nadapoff indicated earlier, Even though there are discussions of some of the issues that come with municipal courts across the country in terms of finances not being appropriate or perhaps not having all of the administrative staff you need to have. And in some states, there's not even a requirement that the judges be licensed attorneys. That's not the case in Alabama. Lawyers who sit as judges in municipal courts in Alabama must be licensed attorneys. And because of that, I believe municipal courts afford us the greatest opportunity to help people at the very beginning of the problems they may have. And because of that, the city of Birmingham has adopted the same standards that the county courts have in terms of accountability. We have had at this court a drug court since 2008. We have had at this court a veterans treatment court since 2011. In fact, both of those were the first in the state of Alabama. Well, the Veterans Court was the first in the state of Alabama. Our drug court has been awarded almost $7 million in federal grants to help people with drug addictions. We believe that if you're going to come to this level of court, we need to try to, no pun intended, arrest the problems you have here so that you do not move on to a higher level of involvement in the criminal justice system. That, I believe, is the greatest opportunity we have. We also see an epidemic here in Alabama of people driving without driver's licenses. It's the same problem across the nation. I've been all across with the American Bar Association and other organizations. People simply don't have valid driver's licenses. And so we decided to make sure that when they leave here, they do have one. So we created programming that requires us to have case management to help people actually walk through the system. We found that the greatest impediment to people making it through the system at this level is certainly economics, but more importantly, in the state of Alabama, we deal with an issue that plagues us in other areas, and that is literacy. Literacy is a problem that that hurts people, prevents them from traversing the legal system as a whole. And so, to that end, we've made sure we have staff full of individuals, probation officers, social workers who can help our citizens make it through the system and resolve their issues here at the lowest level. I believe the greatest opportunity we have in this country right now is to better fund municipal courts. That's interesting because most municipal courts are funded only by local dollars. There is no federal money other than grants, like I mentioned, that flow into municipal courts. There's no state money, really, that flows in Alabama to municipal courts. All of it is funded by the local municipality. And so that gives you some indication of what kind of operation they may have based on the size of the municipality. But with better funding, I believe we can halt some of the social problems we have in their tracks. We operate in much the same way as the larger courts, and probably in some areas even better. We make sure that the problems that people have when they come to Birmingham Municipal Court, they don't have them when they leave. We have 2 years for the most part, according to state law, to help people get things together. We take full advantage of that opportunity to support them. I believe as we go on with this discussion, we'll be able to further illuminate some areas that municipal courts can help in the community. But I will say this about something that Professor Natapal mentioned. A few years ago, several of the presiding judges from courts around the country, after the Ferguson situation illuminated us to some of the issues in municipal court, decided that we needed to have some kind of standards across the nation when it comes to talking about the issues of municipal courts. There were a lot of people who talked about all the problems, but not a lot of people who talked about the promises. So we've been trying for the last few years to create an organization which could fill that space. And I'd love to talk about that more. The National Association of Municipal Courts, we believe, could fill that void and at least give some basic understanding to the general public, give some guidance to the the legislators and the administrative or executive branches that help fill these judicial seats. And we believe the citizens will benefit tremendously from this organization being the kind of liaison to legislative bodies across the country. So we're trying to create that. If you're interested in joining us in that quest, we want you to let us know. Natalie, that's what I'm going to say now, and I'm going to let you get us further down the road.
Judge Sparks, thank you so much. I wanted to use up all the time that we have efficiently. So rather than saying the 17 things that have sprung into my mind, I'm going to turn this over to Blake to share his deep expertise on the ground in Ferguson and beyond with the phenomenon of municipal courts and the programs and the advocacy efforts that our city has engaged in. Blake, please.
Well, thank you very much. I also want to start just thanking you, Professor Natapov, for reaching out and bringing me into this conversation today. And thanks to CGI for hosting all of us. I'm glad to be on this panel with such brilliant folks. I wanted to start out, I think you'll hear some overlap in some of what I have to share and bring to this conversation. But I also have a different perspective in a number of ways, and definitely, I think probably some differing prescriptions on what I see as the opportunities and challenges. So I want to start by giving a little bit of background to offer some context so you better understand the perspective that I bring to this. And first, the first thing I'll say is just that in St. Louis, for those who are not familiar with the St. Louis region, there are 85 municipal courts across 87 municipalities in just St. Louis City and County. And St. Louis City combined and County combined have a population of less than 1.3 million people. So there are, even, in this sort of national scale that you heard, there are a lot of municipal courts generally. There are a lot of municipal courts in St. Louis and much higher than average. We sort of sit at one end of the spectrum in terms of the prevalence of municipal courts here. There were 81 in 2014. So on August 9th, 2014, when Michael Brown was killed by a Ferguson police officer, there ensued, as we've referenced a couple of times, a globally infamous racial justice uprising here in Ferguson, in the St. Louis region, a slew of state law and policy changes focused on the municipal court system in the state and in the region, a federal Department of Justice investigation that really was a full-throated indictment of the local legal system in Ferguson and by extension in St. Louis County. Dozens of federal and state lawsuits focused on that system, most of them brought by my organization, Arch City Defenders, and in collaboration with other co-counsel and other organizations. And sustained media coverage, reporting, public pressure, and really vocal critique of this system of legal fragmentation that we have in St. Louis. And after all of that, from 2014 to today, we went from 81 municipal courts to 85 municipal courts. And I think you could draw a lot of lessons from that, but one of the lessons that I draw from that, and one of my observations, is that once formed, like any institution, municipal courts here have been deeply invested in their own existence and in their own survival against a sustained critique and questions about whether they play a net positive role. My organization, this is the other sort of background I want to share. We're an abolitionist legal organization. I have personally come to identify as an abolitionist. And that means that we sort of think about our work as trying to contribute to a future absent the prison industrial complex generally, because we understand the prison industrial complex to be irredeemably racist and classist and sexist and violent in a number of ways. And so that's that's kind of the value set that we work from. And from that perspective, thinking about what we need to build in terms of our ability to create conditions of safety, in terms of our ability to resolve conflicts on nonviolent terms. For us, municipal courts are the low-hanging fruit of low-hanging fruits in terms of figuring out how we address the problems that municipal courts purport to address. That if we can do that, that really is an entry point to thinking more critically about our criminal legal system more generally. So I want to make 4 points, and I have myself on a timer so I don't go too long. One is that, and you heard this in the introduction, that we are definitely of the view that municipal courts are an engine for criminalizing poverty. This has certainly been my experience and observation. If you walk into a municipal court docket, and I've walked into a number of them, you will overwhelmingly, at least here in St. Louis, you will overwhelmingly encounter people living in poverty. You will be hard pressed to find a wealthy person in municipal court who's not an attorney or a judge. And why is that? Because municipal courts primarily function on financial sanctions. And so for most middle class and wealthy people, the relationship with municipal courts is that they occasionally get tickets, they occasionally pay tickets, and that's sort of the end of the story. It's only poor people who can't quite afford to do that, whose lives then come to be shaped by repeated engagements with municipal court systems. And so for our clients, the most common offenses that are trapping them in these long-term engagements are things like failing to maintain insurance on a car because they can't afford it, or failing to keep a properly maintained, registered, and tagged vehicle, again, because they can't afford it. We serve a lot of unhoused clients, and there are a number who are in court for loitering or trespassing charges because they're unhoused. And then, a sort of catch-all of people that are there because they failed to pay some outstanding tickets and court fines and fees, again, because they can't afford it. So you see this theme that, there exceptions to this rule? Sure. But the rule really is that the vast majority of what is bringing people into these courts is connected to their underlying poverty. And that has been true throughout the work that our city has done in the municipal court system in St. Louis. And so this connects to a second point, which is that I think there's a common view that muni courts serve as a kind of harm mitigation to the defendants, that they would otherwise be subjected to more serious criminal penalties absent the lower risk setting of a municipal court. And while, again, I think that may be true at the margins, I think instead, for most, there's a vast range of conduct that would otherwise be outside of the legal system altogether, that is instead swept in through the mechanism of municipal courts. And I want to just tell one brief client story that I've told many times, but I think it really exemplifies this. This was one of the first clients I ever had at Arch City Defenders. I was 1 or 2 months into the job. And a woman came to our office, and when she started telling us her story, she immediately started getting emotional. She told us that she'd gotten out of jail 1 or 2 days prior. And it started when she was at her job at the airport. She was a transport driver. She put in for a promotion to be a dispatch operator. It was going to be slightly higher pay, slightly better hours. And they ran a background check and said, oh, you have an outstanding warrant in one of the small North County municipalities here. They weren't worried about it because this is St. Louis. That happens a lot. They said, go get it taken care of and then we can process you. So she goes down to the city hall, and this is, city hall / jail / police department / court, and talks to the clerk who runs her name and says, yeah, you have a warrant. You owe, I think the amount was $200, $250. You can pay that now and we'll recall it. And so our client said, hey, I don't know anything about this. I didn't get any ticket. I don't know anything about a warrant. Also, I don't have $200, so I couldn't do that even if I wanted to. They went back and forth a bit. And the clerk said, well, I have to call someone up and, they're probably going to take you in. So sure enough, called an officer from the back, came, put handcuffs on her, took her to jail. She sat in jail 3 days. Our family scraped together the money to get her out. And when she got out, they gave her the paperwork, which showed that the original ticket, which also happened to be for the wrong address, but setting that aside, was for trash lid improperly secured to trash can. Now that's the kind of thing it's outrageous on its face, but that doesn't get adjudicated in a state court. That's the sort of thing that is only enabled by the kind of petty compliance enforcement that can happen in municipal courts and that in some levels can be incentivized in municipal courts. And so that's a major concern, and I think something to keep central when we um, talk about the role of municipal courts and why I do think they're important, particularly important through the lens of thinking really critically about them. Two other points. One, I think it's really critical to keep in mind that there are multiple entities that can profit, depending on the setup. And again, this does vary greatly from one place to another, from municipal court systems. And so the one we talk about the most is the way that municipalities themselves generate a great deal of revenue. That's certainly true. That certainly was part of the, quote unquote, Ferguson story. And we know that's true for a number of municipalities here, that fairly small cities can generate quite a lot of money to the tune of millions of dollars every year through municipal courts. But it's also true that there are other interests, special interests, to use the term, that generate significant revenue from these systems. So you can think about state administrative agencies that collect all kinds of fees connected to licensing or registration. Here, it's our Department of Revenue that's mostly connected to that. That really depends on that system. The private bar, judges, defense attorneys, prosecuting attorneys. We have a particular problem here with a kind of incestuous nature of overlapping roles, where we'll have people who are judges in one jurisdiction and prosecuting attorneys in another, and then they go to the next and they're a defense attorney, and lots of sort of webs of overlapping roles and conflicts. Private entities that are embedded in enforcement schemes. So we have multiple cases currently of sort of joint ventures between cities and towing companies to focus on quote unquote derelict vehicles, towing those vehicles sometimes off of private property, and then charging both the city charging fees to get access to the vehicle and the towing company making money in the process. And then lastly, jails and more commonly, I think actually a compliance industry that has grown quite a lot in the past decade plus and is growing. And here we can think about private probation companies, electronic monitoring, substance awareness programs, and all of these private interests are totally dependent on the coercive power of municipal courts to get their customer base. And so it creates, again, some really perverse incentives that don't really have anything to do with the institution of justice. And then lastly, because I am over time, and this is a repeat point, but I think it bears repeating, that I believe firmly that our insistence on casting what are at their core social and economic problems as legal problems can really crib our imagination in developing more creative, more effective solutions that sit outside the legal system. And so I worry about the impact it has on our ability to problem solve creatively around the real root causes of the problems that appear in municipal courts. So I will leave it there. Looking forward to hearing from others and more discussion.
Blake, thank you so much. So we've heard now the wide variety of challenges and approaches in these municipal courts. Professor Edwards, can you take us back? You've done such important work in giving us a sense of the roots of local courts, and in particular, this idea of localized justice. And your work is complicated. I've learned a lot from it. But I wonder if you can sort of bring us into this world and give us a little sense of its roots, and then also maybe modern resonances, if you if you have any to share with us.
Sure. First, thank you, Professor Natapov, for bringing us all together and for the invitation. And thanks to the rest of the panelists. Um, I'm going to take you, as you say, back into a very strange world that is very distant from us. It's the late 18th and early 19th century in the United States. And at that point, there are not many municipalities. And so municipal courts actually existed as part of this really dense landscape of a variety of different kinds of local courts. And so these are below the jurisdiction of states. They're often below the jurisdiction even of counties. And they're focused in on justices of the peace and the more amorphous kind of areas that they serviced. So justices of the peace were all over in all these states, and they were appointed in a sort of a nebulous fashion. It's not always clear how you got to be a justice of the peace. And then they didn't have a set jurisdiction, but people brought issues to them. And in this institutional context, justices of the peace, this kind of lower, what was called local courts, they had discretion over a wide range of issues. And so justices handled, for instance, like in North and South Carolina, any kind of debt that was under 20 pounds or $20. But then they also handled this wide range of misdemeanors. And at one point in my research, I looked in state law to find out, okay, what are the penalties assigned to, what's a misdemeanor? Let's look at the categories, let's see what the penalties. There are none. This actually caused much consternation on my part. I'm like, maybe I'm doing this wrong. Maybe they're really there and I just can't find them. It's like, no. The point is that states handed over discretion to define what a misdemeanor was, what an offense was, and then what the penalty for that would be. And so a broad range of issues are actually prosecuted under these kind of catch-all phrases of offenses against the peace. And then there would be a wide range of remedies for this, and a lot of them involved actually local surveillance. So people would post bond promising not to, offend again in any way, and then the community would watch them. Central here are two concepts. One is this idea of the peace. So this is a legal concept at the time, we actually still with us today. The concept is that the justices, the justice system generally is designed to uphold the peace of the public order. And that includes everybody, the public order. So it's kind of good news, bad news. You're there whether you like it or not. And the point of the peace is to uphold the existing social relations. So in the late 18th, early 19th century, this is about upholding a rigid hierarchical order that upholds slavery, that upholds the subordination of women, of wives to their husbands, of children to their parents. But at the same time, the idea here is that the peace is about maintaining public order. It's not about upholding the authority of somebody simply because they have that authority. They're supposed to exercise it in a socially responsible way. So that meant there were openings for people to challenge abuses of authority. So there is space here in this system for enslaved people, for married women, for children, for other marginalized people to bring questions about the way that authority is exercised and bring them to an open forum where people actually discuss and talk about this. And it's really interesting to see these kinds of conversations unfold in a time and place where you think that some of this would be impossible. And so more about that in a second. The second important point here is the concept of police powers. So today we think of police powers and we think police powers belong to the people who are designated to be the police. In this period, there are no policemen. There's no police force anywhere, and especially in rural areas. And that's the case in rural areas into the 20th century. Police powers are seen as lying with the people. So this whole system is dependent on people's responsibilities for upholding the public order. It's again a good news, bad news situation. It's like, oh, that means we've designated all these people and they're acting in a way that looks oftentimes like vigilante violence and vigilante justice. On the other hand, this is also about a justice system that is supposedly responsible to the people and resting police powers there. Since all the people in the public order have some sort of power within this system, they're able to bring complaints, they're able to make observations about what is and what is not appropriate behavior in their communities. And they're listened to because access to the system is not dependent on rights, it's dependent on being part of the public order. So it's this really interesting kind of world where there's access to the system. At the same time, the system's upholding rigid hierarchies. But we are having some discussion here about what that should look like and what a community should look like. And it also results in some really interesting, situations where, like, for instance, there's a robbery and then the entire community shows up and they like measure the footprints and they investigate and they follow the footprints and they figure out what's going on. And you realize, oh, people have responsibility for this. They actually take this really seriously, and they take seriously their role in trying to figure out what actually happened. So it's also an interesting devolution of justice into the communities, and you get a sense there too of people's real responsibility and real feeling of that to this whole system. Now, there's a way for people to influence these outcomes too, because justices are located in communities. And so you don't go to like a courthouse. And so you're not going into a foreign place. If you have a problem, you would go find the justice, and the justice is out, like plowing his field. And you say, hey, and he stops and he listens, and then he starts this process. And then the rest of the community would come and watch the process and participate in the process. And you find some really interesting conversations and some really interesting outcomes. And so, for instance, um, um, Judge Sparks was mentioning that he sees a lot of domestic violence cases. You see domestic violence cases quite frequently in these local courts, municipal courts in the late 18th and early 19th century. And, conventional wisdom is that married women were not able to bring these kinds of cases, but they were in these very localized situations. And they did as members of the public order, as complaints against husbands who were misusing their authority and violating the public peace as a result. And you get a sense here of people's embeddedness within the community. So one man's actions would have negative effects on everybody. And a woman who didn't have rights in her own name could then bring a complaint because what her husband was doing had those wider effects, and she too was part of the public order. And recently, as we made this point in recent gun cases, people were surprised. It's like, oh, well, women couldn't bring domestic violence cases. Like, no, they could as members of the public order. You would even find enslaved people bringing cases, not cases in their own names, but they would make complaints to a justice who would then bring perhaps that complaint, turn it into a public matter, because it was an offense against the public order. The enslaved person could not bring the complaint, but they could provide information. And then somebody who could then prosecute the case would do this, and prosecute that case. So it is an interesting world where, as I said, people were responsible for this justice system. The justice system was also very responsive to them because it was embedded in these communities of people who knew each other. And it also had incredible discretion, and this could go wildly in different directions. And so you would see, real, what we would call abuses of authority, of outcomes that were horrific in terms of, demonstrating the inequalities of the time. But then you'd also see a swing in the other direction, where in certain cases, you would see how people were able to influence the system and open up conversations that put real limits on abuses and abuses of authority. And I find it really interesting here because there are 2 points I think to take away. One is that this system of municipal courts is part of this larger system that is deeply embedded in this country's history, because those kinds of local jurisdictions go way back into the colonial period and were the central means of adjudicating all kinds of cases. These courts at this time were also not procedure bound in the way that they are today. And they had discretion to resolve sort of social issues in a way that didn't actually turn them into procedural legal issues in the way that we do today. And it also was a court that was expected to be responsive to the local community, which I think is also really interesting, that people took this really seriously. Justices took this really seriously, as did the people who brought these cases. And then I guess I'm going to add on a third point, which is that it also, I think, reflects this deep knowledge of the law in this period. Like, we imagine people are on the outside of the legal system, they're actually really on the inside. And there was this deep knowledge of, like, how you investigate a case, how you make a complaint, that you needed to show up, that we were all responsible for creating the communities in which we live. And there's something really, I think, interesting and hopeful about that piece of our history, of that community responsibility, of that sense that we can actually solve these problems in a way that makes sense for us all. And that was the institution where that happened.
Mr. Edwards, thank you so much. I feel like we could write a history of the United States and the U.S. justice system through the lens of this conversation. We've engaged the problem of discretion, which haunts our criminal system from policing to prosecution. We've engaged the rock and a hard place that we have created through, I'm going to say it in academic terms. Blake said it much more clearly than I do, but sometimes we call it the criminalization of the welfare state, the idea that we have converted our understanding of community support into a thing that we give people when they are criminalized, that now the burden falls on judges and on courts to provide a thing that the community used to have some sense of responsibility for providing. And it's one of the sources of dysfunction of our criminal system that we have placed this inappropriate and unfulfillable burden on institutions that are not designed to carry it. To relate one story, there's been a lot of litigation around these questions of bail and misdemeanor adjudication in Harris County, Texas. And the sheriff of the Harris County Jail, which is the third largest jail in the country, he has gone on record to complain that because of the overcriminalization of poverty and race, that his jail has been converted into the largest mental health institution in Texas, in the state of Texas. And he said, this was never supposed to be our job. This is not what I signed up for. This is not preserving the public order. This is not preserving the peace. This is dysfunctional. So we have voices from within the misdemeanor system, the criminal system, in these spaces of municipal courts, pushing back against the destructiveness, even as people recognize this deep history of a history of communal accountability, the potential for communal accountability, and as Judge Sparks showed us, places where some courts and judges are trying to make that a reality, even in the face maybe of contrary or unsupportive state law and funding policies. So we're telling this rich story of so many aspects of our criminal system and its intersection with our social system, which is all by itself a reason for us to take municipal courts extremely seriously. We only have about 10 minutes left, so let me do this. One, I want to flag for everyone who's listening. CJI has now put in the chat a survey. If you are an attorney who has worked in municipal courts, or an advocate who has worked around municipal courts, or an individual who has had any experience in municipal courts, please take a look at the survey. And if you'd like to share that information with CJI, this project, these webinars, and this larger project is an effort, as Professor Edwards said, to bring the public more onto the inside, so that our criminal system and municipal courts are not a foreign entity that nobody understands how they work, so that we can really know more about them. And so my hope is that this project will be part of that larger, obviously much longer term effort. With the last few minutes that we have remaining, I want to make sure that our panelists get a chance to say anything that came to mind in this conversation. We obviously have such a broad range of expertise here. We couldn't possibly cover it all. I will note that one of the audience members a couple of times has asked about the difference between civil and criminal, and my focus as a criminal law scholar has been on the criminal aspect of courts, but I think everyone can see that the line is a little fuzzy in municipal court, because nobody thinks that your trash can lid askew on your trash can is what we mean by criminalization, and yet here at the bottom of the penal pyramid, if you will, if at the bottom of our judiciary system, formal lines like civil and criminal blur. Formal lines between lawyers and non-lawyers blur. It's a place of great informality where our usual cut and dried formal lawyerly lines don't always mean the same thing. So if I could just come back through, Judge Sparks, I want to give you a chance to respond. And in particular, what I heard was your an invitation to us to use our imagination, because it is an opportunity to help people. And Blake also a call to imagination. And I think Professor Edwards actually a call for historic imagination. So if I could just invite each of you maybe to give us a couple of minutes on filling out what would it mean to be especially imaginative in these spaces. Judge Sparks, I'm going to out you here because you're being modest about your insistence that the Birmingham court serve its members rather than just criminalize them. And I know you have struggled over the years to assert that model of municipal court. That required great imagination. So I just want to invite you to share a little bit of that courage and imagination here, if you don't mind. You're still muted.
Forgive me.
We got you back. Thank
Yeah,
you.
I'm sorry. It was fascinating listening to the professor's historical discussion about how municipal courts have grown, and the abrogation of the responsibility in the community, I think, speaks more to a lot of the things I believe that Blake is complaining about. Not maybe complaining is a strong word, because as he was talking, I was thinking the conduct that's being swept into municipal courts isn't always being swept into municipal courts because of municipal courts, but because of the way we police things. And municipal court simply becomes the basket that catches all of these situations, much like schools catches a lot of the social ills. Never intended to be that way, but it always goes back. It also goes back to what the professor was talking about. The public has abrogated its responsibility in a number of areas. And because of that, trying to create peace and keep good order, we have, I think, inappropriately placed responsibilities in places like municipal courts. And here we are now, we're trying to right size that ship in the areas that we can. But fortunately for me, Professor, to your point, I have some leeway in how I can go about trying to approach those resolutions. Not every judge has the capacity or the ability or the resources to do the things that we've been fortunate enough to do in Birmingham. And it also depends, I won't take the credit alone, on a receptive administrative body that governs the city. It also depends on a legislative body that's willing to create the ability for the courts to do some special things. So it's a whole city approach that has to take place. But I would be careful as we move forward, and let's not point the finger too much at the different entities, particularly the ones that are trying to make things different. But let's identify some of those areas where it's working well and use those as models in other areas that people can benefit from.
Yeah, I'm just going to take the opportunity to plug the webinar series one more time, because we will have other experts, not me, but other experts later in this series to talk about practices that other courts are developing and models for change. Blake, can I invite you with a few minutes of maybe some closing thoughts on the imagination that you invited us to engage in?
Sure. First of all, I'm in awe of how masterfully you weave together a very broad array of things that came out of this conversation. So thank you for that. And Judge Sparks, I don't mind the word complain. In some ways, I'm a professional complainer. But I do think, I think we probably agree in a lot of ways. The one place I think we would depart is I agree that it is not. I don't place the blame on necessarily the courts or the people functioning in them. I do think they're a kind of receptacle, in the same way that I think jails and prisons are a kind of receptacle. They're the end point for a lot of failed systems and systems that act with disproportionate impact on vulnerable communities. And so my skepticism is always the same way it is with prisons and jails, that I think, build them and they will come, we'll fill them up. I think the same is true in some ways and again, I know the courts that I am privy to here in the St. Louis region, but I think if we built up a larger apparatus, we would see even more of the kind of troublesome activity that we've seen here. And that's what I worry about. I also was really taken, and this may be my last point, coming back to the imagination that we're all calling for. Professor Edwards, I already had written down that I really want to read your book, and now I'm going to.
Yes,
Because
absolutely.
I think that this notion of community accountability is really key. We talk about
I
that a
agree.
lot in various spaces and in organizing spaces, and I think we have sort of lost the thread on what it means as members of a community to be accountable to each other and to be accountable for each other. And we've tried to outsource that to a criminal legal system, and that has some obvious negative ramifications. So I appreciate that history that you laid out and think there's a lot to learn from that.
Thank you, Blake. And Professor Edwards, for those of you who missed it, the title of her book is The People and Their Peace. That's P-E-A-C-E. For those of you listening, Professor Edwards, any closing thoughts about how we might extend the imagination of the communities that you've studied into the spaces that we've been describing?
The context part and the community involvement, I think, is really crucial in taking away, or is a takeaway from the way the courts operated in the late 18th, early 19th century. I mean, you see the problems, obviously, and the importance of context when you have people using the courts to support, slavery. This is obviously a problem, right? But on the other hand, you also can see how community responsibility produced other kinds of really interesting outcomes and approaches. And so, I'd hate to throw out the baby with the bathwater with the local courts and that piece of the history. And I think one of the most important things that I found in some of these courts is the amazing possibilities that people on the margins advocated in the context of these courts. And so, married women thought that actually getting beaten was a problem and they wanted to do something about that. Enslaved people had questions about the way they were treated. Poor people had questions about how property was distributed. People came and talked about land use. I think that all those things were top of mind at this point, and there's a real regulatory tradition in our country dealing with all these kinds of things, and also a history of community involvement that I think could be rescued without taking the bad parts of that system along with us, because we could create a better context now.
Thank you. I just want to add, there was a question in the chat from the audience. What are tips and suggestions for what advocacy organizations or law students can do to advance these questions? And so I just, again, want to reiterate, these are ongoing projects, the webinars, Arch City. I know that your website has a lot of resources and educational resources. Apparently, everybody now needs to read Professor Edwards' book. And the resources on municipalcourts.org, that's the website that I am developing here at Harvard. We intend for it to grow. We hope that it will be resources for students, for advocates, for judges, and for the public. So please remain interested and remain plugged into these questions. I just want to end by thanking our panel. This was just an extraordinary conversation. It's just not a conversation that we've been having. And I hope to be in conversation with you many, many times again in the future. Thank you all so much.